She was a federal judge. She had served some time on the bench, sentencing corrupt officers, dismissing illegal arrests, and protecting the Constitution she had sworn to uphold. She drove a Mercedes she had paid for in cash. She wore her federal court ID on a lanyard around her neck. And on a weeknight, none of it mattered, because to Officer Colton Briggs, she was just another black woman who had no business driving a car that nice. What happened next would ignite a firestorm, expose a corrupt police department, and end careers. What about karma? It came in like a freight train. To understand why this story matters, you have to understand who Judge Nadia Kane was before that night stripped everything down to its ugliest truth. Judge Nadia Kane was born in Savannah, Georgia, not the Savannah of mint juleps and horse-drawn carriages that tourists photographed from open-air buses, but the Savannah of cramped rental houses on the east side, where the gutters stayed full of standing water after rain, and the schools handed out textbooks so old they still referenced the Soviet Union as a current geopolitical threat. She was the second of 4 children born to Dorothy and Raymond Kane. Raymond drove a city sanitation truck for some time. Dorothy cleaned houses regularly and sang in the choir at Bethlehem Church on Sunday with a voice that made grown men weep. Nadia was not supposed to become a federal judge. She was supposed to, according to the geometry of her circumstances, become something modest and practical. A schoolteacher maybe, or a nurse's assistant. That was not a knock against her family. It was simply the math of opportunity in Savannah's east side. The math said, stay small, stay safe, stay within the lines that have already been drawn for people who look like you. Nadia Kane refused the math. She was the kind of student who read every book in the school library before 9th grade and then started requesting interlibrary loans. She worked at a Piggly Wiggly bagging groceries on weekends, saving enough to buy a suit for her first mock trial competition when she was a teenager. She won. She won again the following year. By the time she graduated from Johnson High School, she had scholarship offers from 4 universities and a letter of commendation from a state senator she had never met, who had somehow heard about the girl from the east side, who could argue like a circuit court veteran. She went to Spelman College on a full academic scholarship, graduated summa cum laude, and then, because Nadia Kane did not do anything halfway, she went straight to Yale Law School, where she graduated in the top % of her class. She clerked for the 11th Circuit. She spent some time as an assistant federal prosecutor. She argued complex fraud and civil rights cases with a precision that made opposing counsel visibly nervous. She was nominated to the United States District Court for the Southern District of Georgia by President George W. Bush, a nomination that sailed through confirmation with rare bipartisan support, because even the senators who might have grumbled privately understood that her record was simply unassailable. By then, Judge Nadia Kane had served some time on the federal bench. She had written opinions that were cited by the Supreme Court. She had presided over cases involving public corruption, civil rights violations, and police misconduct, the last category with particular gravity, because she had seen from the highest seat in the room exactly how the machinery of law enforcement could be weaponized against the people it was supposed to protect. She drove a midnight blue Mercedes-Benz E350. She had paid for it at a dealership in Midtown Atlanta, writing a check with her own hand, the way her father had always taught her to buy anything important with money she actually had. She wore her federal court credential badge on a lanyard every single day, not out of vanity, but out of practicality. Because Nadia Kane, with some time of legal service behind her, had learned the way every black professional in America eventually learns, that you carry your proof of personhood close to your body at all times. She was driving home from a late dinner with her husband, Dr. Nadia Kane, a cardiologist at Memorial Health University Medical Center, when the blue lights appeared in her rearview mirror. The road was Route 17, a 4-lane stretch just south of the historic district. Well lit, well traveled, the kind of road you drive countless times and never think twice about. Nadia was in the right lane, doing 38 miles per hour in a 40-mile-per-hour zone. Darius was in the passenger seat, scrolling through his phone, checking on a patient's post-operative report. They had been talking about their daughter's college applications, Northwestern or Emory, the kind of ordinary warm conversation that belongs to a weeknight when dinner was good and the evening felt easy. Then the lights came on. Nadia felt it in her stomach first, that particular tightening that has no name in legal textbooks, but that every black driver in America knows instinctively. Not guilty, not surprised. Something older than both of those things. She pulled over calmly, completely, immediately, coming to a full stop under a streetlight, deliberately under a streetlight, and put the car in park. "Just stay calm," Darius said quietly, though his voice had tightened too. "I am calm," she said, and she was. She was terrifyingly, professionally calm. Officer Colton Briggs was in his mid-30s and had been with the Savannah-Chatham Metropolitan Police Department for some time. He walked with a particular swagger that some officers develop when they have spent enough years in a uniform and encountered enough difference. A rolling, confident gait that said, "I set the terms here." He had a square jaw, close-cropped brown hair, and pale blue eyes that had a way of going flat and evaluative the moment they landed on you. He had never been promoted, not because the opportunities hadn't existed. His supervisors had in fact recommended him twice, but both times complaints from community members, specifically from black residents in his patrol zone, had slowed or stalled the process. None of them had resulted in formal discipline. All of them had been filed and then quietly archived into the particular bureaucratic limbo where uncomfortable paperwork goes to be forgotten. His partner that night was Officer Parker Delaney, still early in his career, and in that stage where he deferred to whoever was driving the patrol car. Parker was not a bad person. He would prove that later in ways that mattered, but that night he was a follower, and Colton Briggs was leading. Briggs approached the driver's side window. Nadia had already lowered it fully. Her hands were on the steering wheel in plain sight. Her badge and court ID were visible on the lanyard around her neck. "License and registration," Briggs said. No greetings, no explanation for the stop. Just the two words delivered in a tone that managed to be simultaneously flat and aggressive. "Of course, officer," Nadia said. "May I ask what I was stopped for?" "License and registration first," he repeated. She handed them over without further comment. She watched his eyes move to the lanyard. She watched him read the words. "United States District Court, Southern District of Georgia, Judge Nadia R. Kane." She watched his face do something complicated and unpleasant. He took the documents back to his cruiser. Darius reached over and took Nadia's hand. Neither of them spoke. Several minutes passed. Then Briggs came back. And this time, his whole posture had changed. The swagger was gone, replaced by something harder and more deliberate. The body language of a man who had made a decision and was committed to it. "Ma'am, I'm going to need you to step out of the vehicle." Nadia frowned. "I'm sorry. Step out of the vehicle, please." "Officer, I asked you what I was stopped for. You haven't answered that question. Can you—" "The vehicle you are operating has been flagged as stolen. I need you to step out now." The silence that followed was absolute. Nadia Kane, a cardiologist who spent his professional life in crisis situations, felt his heart rate spike in a way he almost never did outside an operating room. Nadia turned to look at her husband. There was a single fleeting moment of something raw and unguarded in her eyes. Not fear exactly, but the recognition of exactly what was happening and exactly what it meant. Then the moment passed, and Judge Nadia Kane became the most composed person on that road. "Officer," she said, her voice measured and clear, "I purchased this vehicle from Mercedes-Benz of Atlanta. I have the title. I have the bill of sale. I am a United States federal judge, and that is my court credential around my neck. I would like to know the basis for this stop, and I would like to call my attorney. Ma'am, step out of the vehicle." She stepped out. What happened in the next several minutes was captured on 3 separate recording devices: Officer Briggs's body camera, Officer Delaney's body camera, and Nadia Kane's own phone, which she had quietly placed face up on the dashboard recording before she opened the door. That last detail, the quiet, practiced self-preservation of a black woman who had spent decades in courtrooms and knew exactly what evidence was worth, would later prove to be the most important decision of the entire night. Briggs told her the vehicle's VIN had returned a stolen flag in their system. He did not explain how or when this flag had been entered. He did not ask her for documentation. He did not wait for any kind of supervisor or verification. He told her to place her hands behind her back. "I will not resist," Nadia said loudly and clearly for the recording. "I want it noted that I am complying under protest and that I am a United States federal judge. I want it noted that no verification of this stolen vehicle claim has been sought or received." Briggs handcuffed her anyway. She was placed in the back of the patrol cruiser. Darius, who had gotten out of the car, was told to step back by Delaney, which he did slowly, hands visible. Because Nadia Kane was also a black man on a dark road in Georgia, and he understood the full weight of that fact, even in his fury. "Sir, you need to call Judge Eleanor Hart," Nadia called from the cruiser window before Briggs closed it. "Call her right now." Darius was already dialing. Here is the thing about the stolen vehicle flag, the thing that would unravel everything later in a federal courtroom. It did not come from any active theft report, a Mercedes-Benz E35O, with that VIN had been reported stolen sometime earlier. The theft report had been for a different vehicle, a model with a near identical but not identical VIN mistyped by a data entry clerk at a dealership who had transposed 2 digits. The error had been flagged by the Georgia Crime Information Center sometime before Nadia bought her car. The flag should have been removed. It had not been. Not because the system could not accommodate the correction, but because someone had simply not done their job. But here is the other thing, the thing that would make prosecutors' faces go pale when they finally reviewed the full timeline. Officer Colton Briggs had run this exact VIN before. Sometime earlier, he had pulled over a white couple driving an identical model. The system had returned the same stolen flag. He had checked the owner's documentation, confirmed the discrepancy was a database error, and let them go with a note in his report. Possible GCIC data error. Recommend correction. He had recommended the correction for a white couple. He had not extended the same courtesy to Judge Nadia Kane. He had arrested her instead. Nadia was taken to the Chatham County Detention Center. She was processed. She was fingerprinted. She was placed in a holding cell while her attorney, Elias Ashford, a former federal prosecutor himself, a man who had once argued a case before the Supreme Court, drove across the city with a copy of her vehicle title, her bill of sale, and printouts from the Georgia DM FOV, confirming her ownership. She sat in that cell in the same clothes she had worn to dinner. She didn't cry. She later told Ashford that she spent the time going through the entire sequence of events in her mind, cataloging every detail, noting every procedural failure, filing it all in the precise mental architecture of a woman who had spent her career turning facts into arguments. She was not a victim in that cell. She was a witness. She was building her case. When Ashford arrived and presented the documentation, the desk sergeant, a heavy-set man named Miles Baxter, who had been on the force for some time, looked at the paperwork, looked at Ashford, and said with breathtaking lack of self-awareness, "Well, the flag was in the system. Officer Briggs was just doing his job." Ashford looked at him for a long time. "Sergeant," he said quietly, "your officer arrested a sitting United States federal judge based on a data error he had already identified and flagged when the driver was white. I would choose your next words with considerable care." Nadia was released. She walked out of the Chatham County Detention Center in the same midnight blue dress she had worn to dinner. Darius was waiting at the curb with his hands shaking slightly despite himself. She got into the car they had borrowed from her attorney and drove home without speaking for a long while. Then she said quietly, "We're going to sue them." Darius said, "I know. Word travels fast in a city the size of Savannah, and it travels even faster through the legal community." By the following morning, Judge Elena Hart, Nadia's colleague on the federal bench, a formidable woman who had been Nadia's closest friend for some time, had already called twice. The federal courthouse was buzzing. The United States Attorney had been briefed and was on the phone with the Savannah Police Department's Chief Vance Garrick. Garrick was a career administrator who had spent more time managing optics than managing officers. He was not a cruel man exactly, but he was a deeply political one, the kind of leader who navigated controversy, not by confronting it, but by absorbing it, softening it, and redirecting it until the original shape was no longer recognizable. He had survived several major use-of-force controversies in his tenure through a combination of internal investigations that found no wrongdoing and press releases that expressed deep concern without ever producing accountability. His response to the Kane situation followed the same playbook. In an internal meeting that morning, attended by Garrick, his deputy chief, Lena Hargrove, and the department's legal counsel, Corin Blake, the conversation reportedly went something like this. The arrest had been technically, procedurally defensible because the flag was in the system. Briggs had followed protocol. The problem was not the arrest. The problem was the optics. The solution was to get ahead of the story, express appropriate regret for the inconvenience to Judge Kane, quietly get that GCIC flag corrected, commend Officer Briggs for his dedication, and let the whole thing die. That was the plan. It was a bad plan. It was a bad plan because Corin Blake, the department's own legal counsel, knew it was a bad plan and said so explicitly. I advised Chief Garrick that the disparity in treatment between this stop and the prior incident involving the same VIN represented significant civil rights exposure. He acknowledged this, but indicated he felt the reputational risk of disciplining Briggs was higher than the legal risk of inaction. I disagreed. She put it in writing. That memo would eventually become a key exhibit in the federal lawsuit. Meanwhile, Garrick called a press conference. He expressed deep concern for the experience Judge Kane had endured. He announced a review of the GCIC flagging process. He described Officer Briggs as a dedicated officer with a strong record of service, a characterization that required a fairly creative reading of a file containing multiple community complaints. He said nothing about the prior incident with the white couple and the same VIN. He didn't suspend Briggs. He did not reassign him. Nadia Kane watched the press conference from her chambers, her hands folded on her desk, her expression unreadable. Elias Ashford filed the civil rights lawsuit the following week. The complaint named Officer Colton Briggs, Officer Parker Delaney, Chief Vance Garrick, and the city of Savannah. It alleged racial discrimination in violation of the Equal Protection Clause, unlawful arrest under the Fourth Amendment, and civil rights violations under 42 U.S.C. Section 1983. It sought compensatory and punitive damages. The discovery process that followed would produce evidence that nobody in the Savannah Police Department's administration had apparently thought to hide, perhaps because they had never really believed they would be held accountable for any of it. Elias Ashford was a seasoned civil rights litigator with decades of experience and the particular patience of a man who understood that the truth in legal proceedings almost always surfaces if you are willing to dig long enough and stay calm while you're doing it. He dug. What he found was not one smoking gun. It was an armory. The first major discovery came from the database records. Ashford's team, working with a forensic technology analyst named Harlan Rowe, pulled the complete log of every time the VIN of Nadia Kane's Mercedes had been queried in any law enforcement database. The log showed multiple queries, all in Chatham County, all at night, all involving black drivers. Every single stop had resulted in either an arrest or prolonged detention. None of the drivers had been informed they could resolve the issue by providing documentation of ownership. None had been treated the way the white couple had been treated. Harlan Rowe prepared a detailed forensic report on the query logs. He would later describe his findings in a deposition as the clearest pattern of disparate treatment I have encountered in my career analyzing law enforcement database records. The second major discovery was the emails. Through subpoena, Ashford obtained internal department email traffic involving Briggs, his supervisors, and the department's legal counsel. The emails were devastating. There was an email from Briggs to his supervisor, Lieutenant Grant Ellison, sent sometime after the white couple incident, in which Briggs wrote, "Heads up that flagged VIN is back in rotation, might be worth keeping an eye out." Ellison had replied, "Good to know." No correction request had been filed. There was an email chain between Garrick and Hargrove from the morning after Nadia's arrest, in which Garrick wrote, "Need to get out in front of this. She's a federal judge, for God's sake. The last thing we need is a PR disaster." Hargrove replied, "Briggs's record is complicated. Are we sure we want to tie ourselves to this one?" Garrick responded, "We have to back our officers. Full stop." There was Karen Blake's memo, the one that had sat in Garrick's desk drawer, and then there was the deposition of Officer Parker Delaney. Delaney had clearly spent some time thinking about what had happened that night. He was young, had a wife, and a newborn daughter, and he had an apparently functional conscience. His deposition lasted hours and was the most consequential single document in the entire case. Delaney testified that at the time, Briggs ran the plates. Briggs had received the stolen flag alert and had said before exiting the cruiser, "Oh, this should be good." Delaney had not understood the comment at the time. He understood it now. Delaney testified that he had been aware of the earlier incident with the white couple and that Briggs had discussed it in the break room as a near miss, laughing about how the couple had freaked out when they saw the alert. Delaney testified that after Nadia's arrest, riding back to the precinct, Briggs had said, "Some people need to be reminded that their credentials don't mean what they think they mean." Delaney had written this in his personal journal that same night because, he said in the deposition, "I knew something wrong had happened and I wanted a record of it, even if I wasn't brave enough to do anything about it yet." Delaney's personal journal became a key exhibit. When Ashford finished the deposition, he reportedly sat in silence for a moment, then looked across the table at Delaney and said, "Thank you for telling the truth." Delaney said, "I should have told it sooner." The trial of Kane versus City of Savannah began on a Monday morning in the United States District Court for the Southern District of Georgia. Not in Nadia Kane's own courtroom, obviously, but in the courtroom of her colleague, Senior Judge Everett Langford, a former civil rights attorney who wore bow ties and had a reputation for running the tightest ship in the district. The gallery was packed. Federal judges from 2 circuits were in attendance. Legal journalists from major outlets had reserved seats. Nadia Kane sat at the plaintiff's table in a deep burgundy suit, her hands folded in front of her, looking by multiple accounts less like a litigant and more like a person who had been waiting a very long time for a particular appointment and had finally arrived. The city's defense was handled by outside counsel. The city had retained a prestigious litigation firm from Atlanta, led by a senior partner named Preston Vale, because Karen Blake had made clear that she would not be defending a case she had already told them they would lose. Vale was experienced, unflappable, and working with a genuinely terrible set of facts. He knew it. He focused his strategy on process. Yes, the database error was unfortunate. Yes, Officer Briggs could have handled the situation more sensitively, but he had followed lawful police procedures, and the city could not be held liable for an individual officer's procedural compliance with an erroneous database record. It was a defensible argument, technically. Ashford dismantled it in opening statements. Standing at the podium, speaking in the quiet, even tone of a man who doesn't need to raise his voice to hold a room, Elias Ashford told the jury, 8 members, including 4 black jurors, 2 Hispanic jurors, and 2 white jurors, about the black drivers and the 1 white couple. He put the database query logs on the screen. He put the dates on the screen. He put the outcomes on the screen, side by side. White couple, documentation check, released. Black driver after black driver, arrested or detained for hours. He told them about the email in which Briggs said of the flagged VIN, "Oh, this should be good." He told them about the journal entry, the one where Briggs said that some people need to be reminded that their credentials don't mean what they think they mean. He told them that Officer Briggs had identified this database error earlier, had elected not to correct it, and had used it deliberately, systematically, repeatedly as a pretext. Then he said, "Ladies and gentlemen, Nadia Kane is a federal judge, but I want you to set that aside for a moment. I want you to see her as what she also is. A black woman who was driving her own car on a public road, who presented her credentials and her documentation, who was compliant and professional in every respect, and who was handcuffed in front of her husband and placed in a jail cell because a police officer decided that her credentials didn't mean what they should mean. That's not a procedural compliance case. That's a civil rights case. And it's been a civil rights case since the moment Colton Briggs looked at her court badge and decided it didn't count." The courtroom was very quiet. The defense put Briggs on the stand. It was a strategic calculation that, in retrospect, most legal observers agreed was a catastrophic mistake. Vale had probably known it was risky, but not putting Briggs on the stand would have been its own kind of disaster, an implicit acknowledgement that the officer's conduct could not bear scrutiny. So, Briggs took the stand in his dress uniform and answered questions in the flat, professional tone of a man who had been coached exhaustively. He held up under direct examination. He explained the procedure. He explained the database alert. He explained that he had no way of knowing, at the time, whether the alert was erroneous. He said he had treated Judge Kane with full professional respect. Then Ashford cross-examined him. The cross-examination lasted hours. It was, by the accounts of every journalist and legal observer present, one of the most methodically devastating examinations in recent Georgia federal court history. Ashford moved slowly, piece by piece, building a wall out of every brick of evidence discovery had produced. The earlier incident, the query logs, the email, the journal entry. He put each one up, asked Briggs to confirm or deny, and waited. The moment that everyone who was present would remember came when Ashford placed Corin Blake's memo on the screen and asked Briggs, "Officer, were you aware that your department's own legal counsel advised Chief Garrick that your conduct represented, and I'm quoting, significant civil rights exposure?" The objection was sustained on relevance grounds, but it didn't matter. The jury had seen it. The memo was in the record. Senior Judge Everett Langford, in his bow tie, watched the proceedings with the expression of a man who had seen many things in decades of law and was currently watching something he would tell his grandchildren about. Nadia Kane testified. She spoke for hours. She described the stop, the arrest, the cell. She described sitting in the holding cell and going through the evidence in her mind while she waited. She described walking out. She described what it meant, not just to her, but as a pattern, a system, a weight that is carried invisibly by millions of people who do not have her credentials or her resources or her attorney. She didn't cry. She didn't raise her voice. She was throughout, simply and absolutely clear. At one point, Ashford asked her, "Judge Kane, in your time on the federal bench, you have presided over many cases involving allegations of racial discrimination in law enforcement. How did this experience change your understanding of those cases?" She was quiet for a moment. Then she said, "It didn't change my intellectual understanding. I always knew academically that these things happen. What had changed was everything else. When you sit across from an officer who can look at your court badge and decide it means nothing, you understand in your body, not just your mind, what it means to be treated as though you have no standing, as though the law that you have given your life to does not apply to you. That is not an academic understanding. That is something else entirely. The jury deliberated for some time over 2 days. They found in favor of the plaintiff on all counts. They awarded Nadia Kane $910,000 in compensatory and punitive damages. When the forewoman, a school administrator named Maria Delgado, read the verdict, the gallery erupted. Judge Langford gavelled for order twice before the room quieted. Nadia Kane sat still, her hands folded, and allowed herself once, briefly, to close her eyes. This is the part of the story where the bill comes due. Not just the $910,000, though that was real and significant, and the city of Savannah would ultimately pay every cent of it. The deeper bill, the one that gets collected not by a jury, but by time, by consequence, by the particular gravity of choices that seemed, in the moment of their making, like they might simply be absorbed and forgotten. Colton Briggs was terminated from the Savannah-Chatham Metropolitan Police Department days after the verdict. The termination was framed as being in the best interests of the department, the language of institutional self-preservation rather than accountability. But the result was the same. He was done. He spent the following period attempting to find employment with other law enforcement agencies in Georgia. His termination from Savannah, combined with the federal civil rights verdict now attached to his professional record, followed him everywhere. Agencies conducted interviews and then went silent. One small county department hired him briefly before a community group held a public meeting and presented the county commissioners with a detailed account of his history. He was let go. By the next phase of his life, Colton Briggs was working at a security desk at a strip mall, checking bags and watching monitors. He was making minimum wage. This was not by itself karma. This was simply consequence. The functional result of what happens when a documented record of discriminatory conduct follows a person through their professional life. Karma, in the fuller sense, arrived sometime later. Briggs was pulled over on the interstate by a state trooper named Fiona Greer, who clocked him speeding on a rainy night. It was a straightforward traffic stop, but when Trooper Greer ran his plates and license, a separate, unrelated administrative flag came up, a paperwork error related to a lapsed vehicle registration that Briggs had actually renewed, but the DMV system had not yet updated. Trooper Greer asked Briggs for documentation. He produced it immediately. She verified it, confirmed the flag was a database error, and sent him on his way with a warning about the speeding. He sat in his car for a long time after she drove away. He later described this moment in an interview with a journalist named Selina Hart, who was writing a magazine piece on the case. I sat there and I thought about how she just checked the documentation and let me go. And I thought about the thing I had done and the way I had done it. And I felt, I don't know how to say this right, I felt the size of it in a way I hadn't before. When it's happening to you, even just almost happening to you, you feel how big it is. Selina Hart asked him if he had apologized to Judge Kane. He said no. She asked if he intended to. He was quiet for a moment. Then he said, I don't think an apology would mean much for me at this point. This was perhaps the most accurate thing Colton Briggs had said in years. Chief Vance Garrick retired sometime after the verdict, citing health reasons. He left without his full pension, a finding by the city's ethics board, triggered by Curran Blake's memo and the email evidence produced at trial. determined that his decision to suppress material information about Briggs's prior conduct constituted a breach of his fiduciary duty to the department. His deputy chief, Lena Hargrove, was passed over for the chief position and resigned later. She currently works as a private security consultant. Lieutenant Grant Ellison, who had received Briggs's warning email about the flagged VIN and done nothing with it, was suspended without pay and demoted. He remains with the department at that rank. Karen Blake, who had written the memo, who had told Garrick he was wrong, who had kept a copy of that memo, was promoted. She was appointed the department's Director of Legal Affairs. She implemented a mandatory civil rights training protocol for all officers and a revised database discrepancy procedure requiring supervisory review before any arrest is made on the basis of a stolen vehicle flag alone. There is something quietly important about that last detail. The way the person who told the truth was also the person who ultimately built something better out of the rubble. Officer Parker Delaney, the partner who had finally told the truth in that deposition conference room, had submitted his resignation from the Savannah police force the same week he gave his testimony. He told Selena Hart that he could not, in good conscience, continue wearing a uniform while the department's response to the Kane incident was unfolding the way it was. He enrolled in a criminal justice reform program. He currently works as a juvenile justice counselor in Chatham County, working with young people who have had early contact with the legal system. He is, by multiple accounts from colleagues and supervisors, very good at his job. He reached out to Elias Ashford after the verdict and asked for Judge Kane's contact information. He wanted to write her a letter. Ashford relayed the request. Nadia Kane agreed. She received the letter on a weeknight morning. It was several pages handwritten in careful block letters. She read it in her chambers with the door closed. She later told her husband that it was, in its way, the most honest piece of writing she had received in the entire aftermath of the case. She wrote back, one page, equally careful. She did not offer absolution. It was not hers to give, and she was too experienced a jurist to pretend otherwise. But she thanked him for his honesty and said that the courage to tell the truth, even belatedly, was not a small thing. He keeps both letters, apparently, in a frame on the wall of his office. The $910,000 award was paid in full by the city of Savannah. A portion of it, Nadia announced publicly, would be donated to 3 organizations: the Georgia Legal Services Program, which provides civil legal assistance to low-income Georgians, the NAACP Legal Defense Fund, and a scholarship fund she established at Johnson High School, her alma mater, specifically for students pursuing careers in law. The scholarship is called the Dorothy Kane Memorial Scholarship, named for her mother, who sang in the choir at Bethlehem Church and cleaned houses regularly, and never stopped believing that the math of her daughter's circumstances could be refused. Dorothy Kane had passed away before the arrest. She never knew what happened on Route 17 that night. She never knew about the cell, or the handcuffs, or the verdict, or the scholarship that carries her name. But she knew her daughter. She had always known her daughter. Nadia Kane returned to her courtroom sometime after the arrest. The day she returned, she walked through the lobby of the federal courthouse and past the security checkpoint and up the elevator and through the door of her chambers with the same measured, deliberate pace she had always carried. She hung her coat. She sat behind her desk. She looked at the stack of case files waiting for her attention. Motions, briefs, a preliminary hearing, a sentencing. She put on her robe. She walked out to the bench. She said, "We're on the record. Let's begin." And then there is this. In the period that followed, Judge Nadia Kane presided over a civil rights case involving a complaint filed by black residents of Chatham County against a local municipality for discriminatory code enforcement practices. The case was complex, the evidence dense, the legal questions difficult. She presided over it for some time. She issued a detailed opinion, finding for the plaintiffs, ordering the municipality to restructure its enforcement protocols and pay substantial damages. The opinion was later cited by other federal circuits as a model for analyzing pattern evidence of municipal discrimination. When a reporter from the Savannah Morning News asked her at a public forum that spring whether her personal experience had influenced the opinion in that case, she considered the question for a moment and then said, "Every judge brings their full self to the bench. Every experience, every scar, everything they have learned about how the law works and how it fails. The question is not whether experience influences judgment. The question is whether you have the rigor to make sure it clarifies your thinking, rather than distorting it. I have spent my entire career trying to make sure I do that. I believe I do." She paused, and then, with the closest thing to a smile she apparently allowed herself in professional settings, added, "The law looks different from inside a holding cell. I think every person who interprets it should know that. There is a version of the story that ends with the verdict and calls it justice. The award, the terminations, the scholarship, case closed. But Nadia Kane has been careful in every interview and public statement she has given since the trial not to let the story end there, because the version that ends at the verdict implies that the system worked, that one exceptional woman with extraordinary resources and an extraordinary attorney and extraordinary evidence proved her case and was compensated, and therefore everything is on balance fine. She does not believe everything is fine. She is specific about this in the way that only people who have sat on both sides of the law's apparatus can be specific. She said she had a lifetime federal appointment and could not be fired or pressured by the people she was suing. She had Elias Ashford, one of the best civil rights litigators in the Southeast, who took her case in part because he had a practice and a reputation that could absorb the risk and the time. She had a phone on her dashboard, recording from the first moment of the stop. She had in Parker Delaney, a witness whose conscience ultimately outweighed his institutional loyalty. She had the database query logs that Harlan Rowe could analyze and present. She had Corin Blake's memo. Remove any one of those factors. Remove two. Consider the same stop happening to a woman who works at a nail salon, or to a college student heading home from a part-time job, or to a man who doesn't have a recording running before he steps out of the car. Consider how that case goes. The math of that version is different. This is what Judge Kane talks about when she talks about the case, not the verdict. The other drivers, the ones who were detained or arrested on the same false flag and had no badge and no attorney and no telephone recording and no federal appointment protecting their livelihood. Most of them didn't sue. Most of them did not have the resources to try. One of them, a warehouse worker named Jamal Reeves, had spent a night in jail and lost his job because he missed a morning shift, and his employer didn't accept "I was wrongly arrested" as a sufficient explanation for his absence. Ashford's firm after the verdict, filed cases on behalf of several of those drivers. Some settled. Jamal Reeves received a settlement. He used part of it to go back to school. He is currently finishing an associate's degree. He and Nadia Kane have never met. They were arrested by the same officer on the same false pretense in the same county in the same period. Their lives are separated by everything that structural privilege can create between two people: education, income, legal protection, institutional credibility. And yet on that night, the same handcuffs that touched her wrists had touched his. This is what Nadia Kane means when she says the story doesn't end at the verdict. The verdict was for her. The system that made the verdict necessary was for everyone. On the anniversary of her arrest, Nadia Kane drove the same Route 17 in the same midnight blue Mercedes, alone. She drove it at 38 miles per hour, in the right lane, past the street light, where Briggs had stood with his clipboard and his flat blue eyes. She drove the whole length of it and then turned around and drove it back. Then she went home. She did not speak publicly about what she was thinking during that drive, but she told Darius later that night that the road looked exactly the same as it always had. Well lit, ordinary, the kind of road you drive countless times and never think twice about. She said, "I want to get to the point where I drive it and I don't think about it." "I don't know if I'm there yet," Darius asked. "Are you?" She thought about it. "Not quite," she said, "but closer." That perhaps is the most honest thing in this entire story. Not the verdict, not the endings, not the scholarship or the citations or the forensic report. The fact that justice, even when it arrives in the form of a $910,000 jury award, does not automatically become peace. That the road still carries the memory. That a woman who has given her life to the law still has to work consciously, deliberately, every single time, at not flinching when blue lights appear in her rearview mirror. That is the weight of it, the full, actual weight. And that, more than any verdict, is why this story has to be told. If this story moved you, there's a reason. Because this isn't a story about one bad night or one bad cop. It's about a system where black drivers were treated one way and one white couple was treated another, and the only person with the resources to fight it, one federal judge with perfect evidence and a world-class attorney, is the one we even know about. Imagine the thousands of Jamal Reeveses who never had their moment in court. If you believe that accountability matters, that the truth deserves to be heard, that stories like this one need to circulate further and wider than the courtroom, where they were won, then do something with this video. Hit that like button, leave a comment, share it with someone who needs to hear it. And if you're not subscribed yet, this is your sign, because we don't stop at comfortable. We go where the real stories are.